alcohol may not be delivered to the licensed establishment, and the licensed establishment must pick up the liquor itself. We delved into the legislative history of this provision to see when it was put on the books. As you'll recall, in 1986, the voters approved an amendment to the Kansas Constitution to remove the prohibition on the open saloon and to allow the sale of liquor by the drink in counties that voted to allow such sales. In response to the amendment, the legislature passed 1987 House Substitute for SB 141, which created an amended law related to sales of liquor by the drink. We determined by looking through the committee minutes that during the February 6, 1987 meeting of the Senate Committee on Federal and State Affairs, a conceptual amendment was made to only allow retailers to sell and deliver alcoholic beverages to clubs and drinking establishments when the retailer is located in the same county as the establishment or in an adjacent county. I've got a little bit more information on the bill here, and I won't go through all the procedural steps, but I'll just let you know that once that conceptual amendment made it into the bill, it appears that the provisions were kept in the bill all the way through being signed by the governor. So I'll pause there if there's any questions on this section of law, or if not, I can go ahead and move on to the next section.
Further questions? Any questions? Yes. Representative Long.
Thank you, Mr. Chairman. Did you say in the same county or adjacent county unless they don't deliver? What would you say there about delivery?
Sure, I can go back to that for you. So what we had seen based on the ABC handbooks and based on the statutes is that if you purchase liquor for resale from a liquor store that is in an adjacent county or the same county, they may also deliver that to your establishment. If you purchase it from a liquor store from a county that's not adjacent or the same county, you could still purchase it, but you would have to pick it up as an establishment owner.
Okay, is that in the handbook? I mean, I've never seen that in a drinking establishment.
Sure, so the information was pieced together between the drinking establishment handbook and the retailer handbook. So it may be that that specific sentence about that was in the retailer handbook versus the drinking establishment. But we could circle back to that and give you a copy of that or a link if you'd like.
Okay, thank you. Thank you, Mr. Chairman.
So my understanding is the only time you get delivery if you're in your county or in an adjacent county, if you go outside of that, which you're not stopped from doing, they just don't have to deliver it. Is that your understanding? I know we had a different understanding last session. We thought it had to be in the county or an adjacent county and not, and I got information from Debbie Beavers through Jordan that was a wrong interpretation.
Yes, Mr. Chairman, I think a lot of drinking establishments have the wrong interpretation of that, even in operation today.
Right. So that may be one of the things the committee recommends to ABC is they make that clarification.
Cleared up, yeah.
Okay,
Yeah,
thank you. Further questions of the conferee as to this portion? Without, no other questions, go forward.
Thank you, Mr. Chair. And I just wanted to circle back to the handbook question. So we have a footnote in the memo, and we did cite, it appears that we were relying on information from a KAR, a KSA, and then the handbook for retailers, which cited one of those statutes. So it appears that we also found that information in the retailer's handbook. All right, moving on. So I'll go down to the crime statistics section. So the committee had requested information concerning the potential impact of recently enacted legislation on alcohol-related crime. We contacted the Kansas Bureau of Investigation, who provided the statistics we have in this memo for you. It looks like they've got information from 2015 through 2020. I'm not going to go through and read any of these particular numbers unless you all would find it helpful, but we wanted to provide that to the committee. And I'm happy to answer questions on that if anybody has any.
I have just a couple or one. I was looking at 15, and it looks as though they were, had DUIs 8,377 in 15. It went down. Of course, in 19, they were still down, and they're still down today. But what is the definition of a liquor violation? What's their criteria for that? Is that underage drinking?
So we have a footnote here, footnote 5,
Okay.
and based on the information KBI sent us, they said that it includes minor and possession offenses, open container offenses, and sale to a minor, among others. And if you'd like to find out those other ones, we could follow up with those other crimes that are included in that if you'd like.
No, that was helpful. Thank you. Go ahead. No further questions on that subject.
Okay. Go ahead. Oh, and I guess I forgot to mention too, so according to the KBI, there were some agencies that were excluded from that data set that's included there. Douglas County Sheriff, Lawrence PD, Topeka PD, KCK PD, but it did include, and it also included a couple other ones for a different set of years, but those are all listed in the memo for you. Okay, moving on to the location of farm winery premises question. So the committee requested information concerning the allowable locations of farm wineries and whether those locations are regulated by state statute or local ordinance. We were able to determine that state statutes provide some parameters, such as specific types of zones, for instance, if it had to be agriculturally zoned or not, and specific distance requirements from certain buildings. And then local jurisdictions are able to zone those particular areas and set building codes. So according to KSA 41-710B, we were able to determine that a farm winery must be located in an area zoned either agricultural, commercial, or business. And then additionally, the premises must not be within 200 feet of a school, college, or a church, unless those premises predate the establishment of one of those types of locations. And then the licensed premises must also conform to all applicable building code regulations, if any. And again, those regulations are set by the local jurisdictions.
Thank you, Mr. Chair. On the farm winery, is that in, they have to adhere to the building codes for a agribusiness to be a farm winery, right?
My understanding is for all farm wineries, they have to adhere to those building codes if there's any that's been established by that local jurisdiction.
Okay, and farm wineries are allowed to get a drinking establishment license as well?
That, I believe so. I could defer to Debbie Beavers if she's online to make sure that I'm correct in that. But I believe they're separate licenses.
Debbie, are you on WebEx?
Yes, Mr. Chairman, that is correct. They are able to get an on-premise drinking establishment license. It is a separate license as long as they're in a county that authorizes liquor by the drink.
Thank you. Go ahead, Representative Tarwater.
And is that, they have to get it? Like if they apply for it, the county can't deny that? Is that correct?
For you, Debbie.
The county could request a hearing before that license is issued.
And would that mean that they could deny it based on the hearing?
I believe that's possible. It's not happened that I'm ever aware of.
All right, would there be a reason that a county could have higher building codes for a farm winery in the case that they wanted to be a drinking establishment?
I cannot speak on behalf of the local codes.
Is that something we could get
I can have research do that and provide that information to the entire committee, if that's agreeable to you, Representative.
That would be great. We have a very popular winery in southern Johnson County, almost Miami County. And they are a farm winery, but when they went for their drinking establishment license, they were told they needed a sprinkler system. but they didn't need it for a farm winery. So I would like to know if they could do that or not.
I would ask that you give the specifics to the research folks, and they can follow up on that.
Thank you.
Thank you. Further questions as to the farm winery requirements? Seeing none, Jordan, go right ahead.
Thank you, Mr. Chair. Next, I'll be moving on to sampling requirements for micro distilleries. So during that August 31st meeting, you'd asked about micro distilleries possibly handing out sample bottles or how they'd be able to hand out samples, and then specifically in the instance of the state fair. So some of the state fair information will be covered by the revisor staff later, but I'll give you what we have in our memo here, and then we can see if there's any questions, and some of it might be clarified later as well. So first of all, we looked at sample overall, and it's defined in law as not more than 1/2 ounce distilled spirits, 1 ounce of wine, or 2 ounces of beer or CMB. Sampling rules for farm wineries, microbreweries, and microdistilleries are set out in statutes specific to each license type. However, it appeared that similar rules apply for each type of licensee. The committee specifically asked about sampling at the state fair, so we've only included references just for those microdistillery statutes. Statutes may only be provided at a special event, samples may be only provided at a special event monitored by the director of ABC in a wet county that allows the sale of liquor by the drink. Licensees are required to notify the ABC before participation in the event, with electronic notification required not less than 10 days before the event. A special event is defined as a public or private gathering of 2 or more persons, arranged for a specific commercial, charitable, or social purpose, having a limited duration, and not conducted in the ordinary course of business. Consumption of alcoholic liquor at the state fairgrounds is restricted by statute with certain exceptions. Specifically, consumption of alcoholic liquor is allowed on the day of a parimutuel race held pursuant to the Parimutuel Racing Act and during non-fair days in conjunction with the State Fair Board sanctioned event, and those sanctioned events require at least 75 guests, subject to any restrictions set by the board. The statute, we did not see any further provisions in there concerning the consumption of alcoholic liquor other than the consumption of domestic beer or wine. Consumption of beer, wine, or wine imported for educational purposes is allowed on the state fairgrounds, but only for the purposes of judging competitions. Consumption of domestic beer or wine is also allowed during the days of the state fair, only in an area leased by the board to a person with a temporary permit.
Questions as to this? Yes, Representative Reese.
Thank you, Mr. Chairman. Is the definition of beer at the state fair, is that when we're considering cereal malt beverage up to 6% or stronger? Is there something that's going to define that?
So it's listed as domestic beer. That's the information we'd included, which would be that strong beer. I'd see if Matt might have any clarification to make on that. Okay, so Matt said he'll follow up on that. Thanks.
Okay, Matt will cover that when he does his portion. Further questions as to the state fair? You know, this was a pretty hot subject last year. The Senate actually passed a bill. The House did not. So it's going to be an issue. I know my vice chair has mentioned that to me, that he wants to bring that back up this year, and we'll probably take it on. But with that, go ahead, Matt.
Good, thank you, Mr. Chair. So I'll go ahead and move on to the liquor and CMB
Jordan,
tax
sorry.
rates. That's okay, I knew what you meant.
I was looking at Matt, and okay.
So the committee requested information on tax rates for liquor and CMB. So we pulled some of the information off the Department of Revenue website. We just pulled the fiscal year of '21, which had ended on June 30th of this year, and then we included FY22, and the information we pulled just had the first 2 months of that, and September recently ended, so I would expect that information will probably be up sometime soon. I won't go through all the numbers, but I'll go through what we had found as far as the tax rates in our memo, and then see if there's any questions on that. So Taxes are levied upon the person who first manufactures, uses, sells, stores, purchases, or receives the alcoholic liquor or CMB. If the liquor or CMB is manufactured and sold in the state, the taxes are paid by the manufacturer, microbrewery, microdistillery, or fine winery producing it. If the liquor or CMB is imported into the state, taxes are paid by the distributor. Manufacturers, microbreweries, microdistilleries, farm wineries, or distributors at wholesale of alcoholic liquor or CMB are exempt from paying such taxes on those wholesale transactions upon providing proof the product was produced in Kansas but shipped out of state for sale and consumption in another state. And then we've listed the tax rates for production and sale of liquor and CMB. Spirits, there's a gallonage tax of $2.50 per gallon due at the time of manufacturing or bottling. Wine has a 30-cent per gallon tax on wine containing less than 14% alcohol by volume. If it's fortified wine that has more than 14%, there's a 75-cent per gallon tax on that wine. And then for spirits imported for use in manufacturing wine, there's a $2.50 per gallon tax. For beer and CMB, there's an 18-cent per gallon tax on beer and CMB. For wort and liquid malt, there's a 20-cent per gallon tax. On malt syrup and malt extract, there's a 10-cent per pound tax. And then on hard cider, there's a 30-cent per gallon tax. And I'll stop there for the production taxes, and then we have some other information about enforcement tax.
Questions as to the tax rates on the different? Yes, Representative Tarwater.
Thank you, Mr. Chair. I think during our initial meeting, we discussed alcoholic candy. Is that taxed when it's created, or how is that taxed? Thank you.
Maybe I should refer to Debbie if there is a tax on that, or Jordan, whichever.
Thanks, Mr. Chair. I would defer to Debbie on that specific question. We can always provide some follow-up information as well if needed.
Okay. Let me ask Debbie. Debbie, are you aware of the tax on the candies that contain alcohol?
Yes, Mr. Chairman, they are taxed, and it's dependent upon the type of alcohol that is contained within the candy.
Okay, there's a limit to the percentage of alcohol. Is that correct? It's like 1.5? I remember doing that candy bill a few years ago.
Right, it's not taxed unless it has at least 1%.
Okay. Was that helpful? And I'll have Gordon pick up the other, or not Gordon. I went from Matt to Gordon, now to Jordan. Jordan to do that. Okay, thanks, Jordan.
Thank you, Mr. Chair. Are there any other questions before I move on to the enforcement tax section?
Seeing no questions.
Okay. Moving on to liquor enforcement tax, there's an enforcement tax of 8% that's levied on the sales of liquor and CMB. This tax is levied in place of sales tax, and it's paid by the purchaser and collected by the seller. So the tax is levied on the following sales: liquor sold by a distributor to clubs, drinking establishments, caterers, or temporary permit holders; liquor sold by a microdistillery, microbrewery, or farm winery to consumers for off-premises consumption; and then liquor, CMB, and non-alcoholic malt beverage sold by retailers. And we wanted to note for you all, a retailer who sells alcoholic liquor holds a different license than a simply CMB retailer who may only sell CMB and beer containing not more than 6% alcohol by volume.
Any questions as to the liquor enforcement tax? Seeing none.
Okay. Moving on to the liquor drink tax. So a drink tax of 10% is levied on the sales of liquor and CMB by any club, caterer, drinking establishment, public venue, or temporary permit holder. That tax is paid by the consumer and collected by the seller. Any of those licensees I just mentioned that serves free samples is also responsible for paying the drink tax on those samples.
So when they're giving it away as samples, but they still pay the tax on it, my understanding.
Right, and my understanding is they would have to pull that bottle out of their inventory as well for that.
Okay, good. Any questions? Seeing none, move along.
Okay. And then finally, we've got the retail sales tax by CMB retailers. So CMB sold by either off-premise or on-premise CMB retailers is subject to the applicable retail sales tax. We just noted for you again that CMB retailers may only sell CMB and beer containing not more than 6% alcohol by volume.
Questions as to that section? Seeing none. Thank you, Jordan.
Thank you, Mr. Chair.
Matt, with the revisor's office, is up.
Thank you, Mr. Chairman. Good morning, committee. Per revisor policy, going to have the mask on. If you have trouble hearing me, let me know and I'll take it off.
Whatever you feel more comfortable with.
So, just like Jordan, after the last meeting, our office was asked to answer some questions. I'm going to walk through each question individually. If there are questions, please stop me and I'll try and address those. To jump at Representative Ruiz's question, start off the bat. So KSA 41719 concerning consumption on state fairgrounds includes provisions for both domestic beer and beer. So both have the availability to be consumed on state fairgrounds. So the first question in the memo detailed is there a conflict between the farm winery Kansas-grown product reduction and agritourism tax credit eligibility? So the Agritourism Promotion Act authorizes a tax credit for costs that are incurred for liability insurance for agritourism activities in Kansas. And then I've included some definitions in the memo in terms of what is an agritourism activity, what's a registered agritourism location, and a registered agritourism operator. So KSA 321438 authorizes a tax credit for the first 5 taxable years commencing after a taxpayer opens their business. So the tax credit is for 20% of the cost of liability insurance for a registered agritourism operator who starts an agritourism activity. That tax credit cannot exceed $2,000 a year, and then there's an ability to carry it over if you exceed that. So the Secretary of Wildlife, Parks, and Tourism maintains a list of all the registered agritourism operators, the registered agritourism activities that are conducted by the operator, and the registered agritourism locations. And that's used to promote them, and the idea is to encourage tourism. So farm wineries that are operating an agritourism activity can register as agritourism operators and thus be eligible to receive the tax credit. Prior to July 1 of this year, farm wineries were required to use at least 30% of Kansas-grown products in the production of domestic table wine and domestic fortified wine. During this past session, HB 2137 was passed, and that reduced this percentage requirement to 15% after July 1 and eliminates that requirement completely on January 1, 2023. So after that date, no Kansas-grown products will be required in the production of domestic table wine and domestic fortified wine. So this could allow a farm winery that did not grow any products in Kansas to register as an agritourism operator and receive the tax credit for liability insurance costs associated with an agritourism activity, if they are operating that agritourism activity. So that's the first question. If there are questions on that, I'd be happy to address those.
Questions as to, yes, go ahead, Senator.
Thank you, Mr. Chairman. So the Secretary of Wildlife keeps a list of all these agritourism businesses. Does anybody go back and check to see that they're actually engaged in that activity, or is it just a self-assured, we just self-report?
Sure, so there's that definition of what is an agritourism activity, and you have to be conducting an activity. As far as whether there's a recheck, I don't know. That's not required in statute. Perhaps the Secretary does. I couldn't speak to whether that is occurring or not.
Okay, Thank you.
You're welcome. And you may want to talk with the secretary as to that. Further questions? Seeing none, let's go to the next question.
So second question was, what changes would Senate Bill 2 make regarding a Kansas State Fair common consumption area? The chairman's already referenced this, an issue that will probably be discussed. So SB 2 was introduced last session and would amend a number of statutes governing the sale and consumption of alcoholic liquor on state fairgrounds. So currently, 41-719 generally prohibits the consumption of alcoholic liquor on public property, but makes an exception for the fairgrounds. Patrons of the fair can purchase beer and wine from temporary permit holders operating at the state fair. The patron then has to consume that beer or wine on the temporary permit holder's premises, which is leased from the fair. Senate Bill 2 would allow the Fair Board to designate an area that is more expansive than the leased premises of a temporary permit holder, which would be comparable to a common consumption area. Patrons could then consume beer and wine within that larger consumption area. The boundaries would have to be designated by and marked with a three-dimensional barrier, and must be signs, a posted map, and other means of reasonably identifying the area. The bill would change where beer and wine can be consumed, but patrons would still have to purchase the beer and wine from a temporary permit holder. Senate Bill 2 would also amend the alcoholic liquor enforcement tax to direct a portion of that tax revenue that was derived from sales on fairground property to the State Fair Capital Improvements Fund. So under the bill, 70% of the tax revenue from both the 8% retail sales tax enforcement tax, retail sale enforcement tax, and the 10% drink sale enforcement tax would be credited to the State Fair Capital Improvements Fund. And then just kind of the history, the bill passed through the Senate last year and is in the House right now. So happy to answer questions about that as well.
Questions as to the State Fair, which was Senate Bill 2 from last year? Seeing no questions.
All right. So the third question is, what is the current law regarding distributor franchise agreements? So under the three-tier system of alcoholic liquor regulation that we have in Kansas, the director of ABC issues licenses to distributors. Those licensed distributors acquire alcoholic liquor from manufacturers or suppliers and resell the product to retailers and licensed clubs, drinking establishments, caterers, public venues. Distributors licensed are restricted by franchise agreements with manufacturers and other suppliers and can generally only sell certain brands of alcoholic liquor within a fixed geographic area of the state under the terms of those franchise agreements. So such agreements are generally governed by KSA 41-410. The statute requires that both the distributor and the manufacturer or supplier file notice with the director of ABC that a franchise agreement exists. The notice must include a description of the geographic territory where the distributor may sell one or more brands supplied by the manufacturer. Statute also requires that these territorial franchise agreements provide exclusivity, or generally requires that they provide exclusivity of distribution of a brand to the distributor. The statute further provides that a franchise agreement can only be terminated or modified, or the geographic territory designated in the agreement can only be altered for a reasonable cause. The termination, modification, or alteration is effective unless it's not effective unless written notice of the change is submitted to the director at least 30 days prior to the effective date of it. And there's no requirement that the director approve such termination, modification, or alteration in geographic territory. There is a statutory exception to the general requirement of a franchise agreement in KSA 41-701D. It provides that if a distributor refuses to sell alcoholic liquor to a retailer as authorized by a franchise agreement, another licensed distributor may sell alcoholic liquor to that retailer. And KSA 41-332 also authorizes the director to issue a temporary permit to a manufacturer to import alcoholic liquor or CMB into the state to a licensed distributor, even though they do not have a franchise agreement. The permit must be specific to the type, brand, and quantity of alcoholic liquor or CMB that's being imported, and the distributor is restricted from reselling such imported liquor or CMB. Stop there if there are questions on that issue.
Questions from the committee? The chair has one. Go back to the first part on the termination, reasonable cause. Is there a definition in the statute what reasonable cause is?
No, there is not. So,
Or anywhere in Kansas
yeah,
statute?
so it'd be based off of, it's going to be a fact-specific, this circumstance, and it's kind of like whether the specific situation warrants reasonable, or a change, a modification. And if there is a dispute about that, probably ultimately it would be decided in court.
Right, and then, but there's no direction for the court
As to reasonable cause?
at what reasonable causes is. I mean, we don't really have, we understand what clear and convincing evidence is. We know what preponderance of evidence is. We know what probable cause is, what would lead a reasonable, prudent, and cautious individual to come to that conclusion. But and judges hate statutory language like this, because one judge in one county may find a reasonable cause, and another judge, and then it ends up in the Supreme Court, and then they will maybe define it, or maybe they choose not to. But I would ask the conferees that are in the room or listening if they could address that, because it's basically a contract law between two parties. And should not the two parties make that determination of what would be reasonable cause for termination? I don't know, but I would like, if the conferees are interested in that area, to address that area for the committee, because it's vague. And vagueness always ends up in conflict. And I don't know if it's ever happened. And I could not find any case law on it. But that's one of the areas that it just kind of struck me when I said, okay, what's the definition? And we don't have a definition. Correct. Based on my inquiry, is there any questions? Seeing none, let's move to the next question.
All right, thank you. So the fourth question was, what is the current law concerning what farm winery licensees are permitted to do? And there's a couple statutes just kind of lay out what a licensee is able to do, and I'll kind of just jump through those. So if you have a farm winery license, you are able to manufacture up to 100,000 gallons per year of domestic table wine and domestic fortified wine. You're able to sell that wine that's manufactured under your license. You're able to manufacture for and sell to holders of producer licenses that are authorized under KSA 41355. You're able to sell and serve free samples of wine that are manufactured under your license on licensed premises and at special events. You're able to sell domestic wine, domestic fortified wine, and other alcoholic liquor for consumption on the licensed premises without a CDNE license. And you're able to sell and ship wine manufactured by the licensee in the original unopened container to consumers inside Kansas pursuant to a permit issued pursuant to KSA 41350, and to consumers outside the state pursuant to the requirements of the jurisdiction where the wine is to be shipped. KSA 41308A also authorizes farm winery licensees to obtain up to 3 winery outlet licenses upon application. A winery outlet license allows a licensee to sell wine manufactured by the licensee on the licensed premises and at special events, serve wine that's manufactured by the licensee or imported pursuant to law on the licensed premises, and to manufacture domestic table wine and domestic fortified wine, provided that aggregate amount produced by the farm winery licensee and all winery outlets does not exceed 100,000 gallons per year. 41308A further authorizes a farm winery licensee to import wine from outside Kansas for use in the production of its domestic table wine and fortified wine, and is required to report any such imports on forms prescribed by the director of ABC. A farm winery or winery outlet may sell domestic wine and domestic fortified wine in the original unopened container to consumers for consumption off the licensed premises at any time between 6 a.m. and 12 midnight on any day. And then lastly, KSA 41351 authorizes a person who is licensed to sell wine pursuant to 41308A to apply to the director for an annual farmer's market sales permit by paying a fee of $25. The permit allows the licensee to sell wine in the original unopened container that was produced and bottled by the licensee at farmers markets. The locations of the farmers markets at which wine are to be sold must be specified in the application to the director of ABC, and then the director notifies the city, county, and applicable law enforcement agency where farmers markets are held and of the issuance of a permit for the sale of wine at such farmers markets. Happy to try to answer questions on that one.
Yes, Representative Tarwater.
Thank you, Mr. Chair. So now I'm kind of confused because earlier I asked if they could get a DE license, and the answer was yes. But this number 5 seems to indicate that they may not need a DE license, that they could go ahead and sell spirits and beer on premises. Is that correct?
So that's what I have. I'm going to go double check that one.
That would be nice to know. I mean, there's
Yeah.
several wineries out there that are not currently doing that, and after events, they're picking up beer cans in their parking lot from people that bring their own and go out to their cars and drink. And so it would be nice to have that income for the farm wineries.
A good point. And Matt, do you think we could have that answer by this afternoon?
Yeah, I'll go double check on that. I apologize for not having certainty on this, but I'll double check on that.
Okay. And we'll try to get an answer for you, Representative, by the afternoon. Any other questions? Go ahead, Matt.
All right, question 5. What restrictions are there in current law on in-state shipping by farm wineries, microbreweries, and microdistilleries? Farm wineries are authorized under KSA 41308A, paragraph A10, to ship wine in-state if the winery obtains a special order shipping license under KSA 41350. Microbreweries and microdistilleries do not have the ability to ship product in-state. So under KSA 41350, a winery may obtain a special order shipping license to ship wine upon order directly to consumers for personal or household use in Kansas. The purchaser is required to pay the purchase price and all shipping costs directly to the permit holder. Enforcement taxes are paid solely on the purchase price and not on shipping. A holder of a special order shipping license may not ship more than 12 standard cases of wine of one brand or a combination of brands into the state to any one consumer or address per calendar year. Stop there and see if there's questions on that.
I see no questions. Go ahead.
That's what I have for those 5 questions.
Okay.
If there's any general questions remaining, happy to answer those as well.
Committee, any general questions to Matt in the Advisor's office? Matt, great job. Both you and Jordan have answered our questions. What's in the statute?
The ones that are hanging out there.
We've just had Kansas Liquor Law 101. So you have all the information that we've asked for. So next, we're going to go to the conferees. I have a number of conferees, and we'll take the first one. And I've not limited time. I may, if you take 20 or 30 minutes, I'll probably stop you. But normally, we don't have that. So the first up would be Mike O'Neill with Walmart. And good morning, Mr. Speaker.
Morning, Mr. Chairman, members of the committee. I appreciate the opportunity to appear before you on behalf of Walmart. First of all, we want to express our appreciation for the interim subject. Those of us that don't deal with alcohol-related statutes day in and day out have been overwhelmed with the amount of alcohol legislation that has come through the legislature in the past few years, which is an indication of how the The industry is evolving to meet consumer demand, and we appreciate the fact that Kansas, at least up to this point, has been very responsive to consumer needs and requests of the industry to modernize the liquor laws in the state. And so we think it's an appropriate time for you to take a look and take an inventory of what's already done and what would be the logical next steps in the process to either level the playing field or continue to address consumer expectations. And in that regard, our ask is actually very simple, and that is the ability to not only sell but to deliver to the ultimate consumer cereal malt beverages. We belong to a loose coalition of C&B retailers who have a similar desire. Late in the session last year, we introduced House Bill 2453, which we wanted to have drafted to get at least on the table to open up the discussion of delivery of C&B. So in terms of, we know this is not a hearing on a delivery bill, so I'm not going to get into the details, but for a little background, you can take a look at that bill. I would also hasten to add that that's not a finished product in our estimation because we continue to work with coalition members to fine-tune it. We still want to sit down with ABC to get their advice and address any concerns so that the product that we have for the 2022 session is the best product. But simply stated, we are in a situation right now where a store like Walmart can deliver virtually anything that they have in their stores except cereal and malt beverage. And obviously there's a lot of consumer demand to have that product added to the list of things that they can have delivered. They can certainly pick it up now. And in some respects, the silver lining, if you will, of what we went through with COVID is it allowed government and the legislature to experiment with certain relaxing of regulations and statutes to accommodate some of the unique circumstances that consumers and retailers faced during COVID. And some of those, the legislature and the state have decided to make permanent, and some of those have educated and helped inspire some thought of more things that we can do to help the retailers and consumers once the epidemic is over. And the thing that, the other silver lining, if you will, is that the darn epidemic has lasted long enough that we've had time to actually see if these experiments, if you will, in relaxing regulations and putting new laws in place are working. And I think I'm happy to report, and I think you've probably gotten the same information, that they've worked very well with very little pushback. Walmart is the largest retailer in the country, already has a great track record in the way they deal with alcohol, but they also deal with other age-restricted and restricted products, whether it's over-the-counter medications or it's pharmacy medications. So they already have an established good track record in how they handle products that are heavily regulated, and they are certainly ready to enter this field of delivery. There are others who are more experienced with the alcohol side than I am, and so I'm not going to take a lot of time. And again, I'm not going to try to dive into the provisions of 2453 because that bill will probably change somewhat. We have, the way the bill is drafted, it's just your C&B retailers that are included, but if there's interest in expanding this to liquor stores, we would have no particular problem with that. We understand that they may not have an interest, but that is a question certainly they can answer either today or tomorrow. With that, I'd be happy to stand for questions at the appropriate time, Mr. Chairman.
Thank you. Questions of the conferee? Yes, Representative Reese.
Thank you, Mr. Chairman. Mike, it's good to see you. How would these deliveries be handled by contract drivers? Since we're dealing with alcoholic beverages, it would be different than delivering groceries. And I've never had groceries delivered to my house. How does that work? Do you call Uber? Do you call
In most cases, it can be the retailer's own delivery, but it's likely going to be third-party delivery services. So there would be a delivery permit that would be issued. There would be regulations affecting them. There would be a written contract, requirements of having the purchase be prepaid with an individual providing proper identification to ensure that they are of age. And then the drivers on delivery are going to have a list of things that they must be assured of. The individual who made the order must be present. They must produce the same identification that they provided the retailer. In other words, there's already provisions in place that would protect the integrity of the delivery itself. Many of those things are spelled out in the bill that we had introduced. And again, if ABC has any different or additional things that they would like us to consider, we're certainly open to that. But does that help answer your question?
So the people who deliver the CMB for Walmart would be contracted drivers who bear the liability and responsibilities for
Yes.
completion upon delivery?
Yes, sir. Requirements of insurance, proper licensure, proper age requirements, all those things would be included.
Further questions of the conferee? Yes, Representative Tarwater.
Thank you, Mr. Chair. Are there other states, what other states are doing this, and how long have they been doing it, and has it been successful in increasing sales, or is it just redistributing them?
The answer is yes, there are other states. I knew that I would probably get that question, and I've asked to see if I can get a list of those states. I do not have that list today. I don't know whether research can help with that, or I'll be happy to circle back with that. I know that this is going on in other states. It's going on in other states successfully. It is something that consumers have requested and appreciate. And to my knowledge, we have not had any significant issues with that. But I cannot tell you today all the other states that currently have this in place.
Thank you. I'll ask research to see if they can find out what other states are doing. Since the pandemic, and you probably don't have this number, but I would appreciate if you can get it to me, the percentages of home delivery, what they've increased for the, I just know that I have a daughter-in-law that never shops. She gets everything delivered to her house. And she has 3 kids, and that's a great convenience for her, but it was brought about by the pandemic. And I just wondered about the increase of home deliveries that have occurred since the pandemic, the percentages.
Good question, and I can just tell you globally that there's been a market increase, but I'll try to get to you some specifics, at least from the standpoint of my client.
Okay, thank you. Further questions? Yes, no? No questions. Thank you.
Thank you, Mr. Chairman.
Thank you, sir. Next up is Sheila Regit Dillons. I'm sorry, I'm horrible about butchering names.
That's okay. Sheila Regier.
Regier,
Yes.
okay.
Yes, with Dillons. Thank you very much for the opportunity to speak today, and I appreciate any consideration. Similar to Mr. O'Neill, we echo those comments from Walmart. Really looking forward to ways that we can continue to advocate for our customers, especially when it comes to providing additional products and services that they're demanding. I serve today as Corporate Affairs Manager for Dillon's Stores, been in this role for 3 years now, but have proudly served my divisions for 26 years in the state of Kansas. So when we look at highlights, our customers have shared great feedback since we were able to modernize Kansas legislation, thanks to the bill that had passed in 2017 by allowing our store locations to provide cereal, malt, beverage, beers with not more than 6% alcohol. But from our perspective, COVID-19 has completely changed the landscape when it comes to how customers shop our stores, with a vast increase of not only pickup but delivery options. So when our customers turn to us, they're looking for all of those essentials, the fresh foods, essentials for their families. One of those items that they cannot purchase, that they can purchase inside of our stores, would be the cereal malt beverages, beers, seltzers, things that have grown greatly in demand, not only in the past year, but past several years now that we're able to sell those items inside our stores. And thanks to our partnership with Instacart, we're able to meet that demand from our customers. They're turning to us from a convenience standpoint, from a safety perspective, and then also just an ease of shopping. Many of our customers who turn to us for pickup and delivery services have continued to use that method to provide food for their families versus shopping for us inside the store. So unfortunately, not all those items are available right now. Looking at those cereal malt beverages, items that have that 6% or less per volume, all of those items with seltzers, with beers, looking for ways that we can meet that demand and expand those items to our customers. We're currently performing this function with delivery with our stores in Nebraska and in Missouri under our Bakers and Gerb's banners, conveniently with our third party, whether it's Instacart or through Shipt, so we can do this responsibly. We have the knowledge and the background and experience to do this safely for our customers, but we'll continue to advocate for them, just as we've done in the past, to be able to provide that ease of shopping, the convenience, and that safety for our customers as well. But I would appreciate any consideration, similar to Mike and, Mr. O'Neill, what he had mentioned from Walmart in terms of efforts to put forward future legislation to expand the delivery services for our customers. We'll definitely advocate on that, and looking forward to any consideration that you could share. I will stand for questions as well.
Representative Reese?
Thank you, Mr. Chairman. And thank you for being here this morning and take time out of your busy schedule. Can you tell me or tell the panel what percentage of customers that you serve in Nebraska, Missouri that order cereal malt beverage and alcoholic beverages for delivery?
For proprietary reasons, I would not be able to share specifics, but I can tell you throughout the entire Kroger company, when we look at our fiscal year, digital sales with our online customers had grown 114% over last year. So that demand is there. Our customers are turning to us for that convenience. And as I mentioned, many of our customers who are shopping inside our stores had not gone back to our store locations, choosing delivery or a pickup service in lieu of shopping inside our stores. I can tell you I've done delivery pickup many times before, and it's very convenient. It's a way that you can order your items online and either pick those up at our store or even have those delivered. But because of restrictions, if I choose to purchase a seltzer or a beer, it is an automatic trip to the store instead of that convenience of having it delivered right to your home.
Thank you for that. So you're saying that in Missouri and Nebraska, there's no data that shows the number of the volume of beverages being sold to the home, directly to the home from your stores?
I would have information available. Let me do some research to see if that's details that I can share. But with proprietary reasons, I don't know that I'd be able to break it out specifically for you.
Okay, maybe we can talk after.
Yeah,
Sure. Thank you, Mr. Chairman.
Nebraska and Missouri, how long have they been doing home delivery?
So
Was it just for the pandemic, or did they have a statutory
No, we started before the pandemic. If memory serves me right, 2016, when we instituted delivery services, pickup service, online grocery, with our partnership with Instacart and Shipt.
Okay, thank you. I'm going to ask the reviser to get me copies of those statutes in Missouri and Nebraska. And what other state?
There's several states that we operate throughout Kroger. I was, as Mr. O'Neill mentioned, working to gather that information myself. I can confirm with the states that I have so far, in 24 states that we operate, there's only 8 locations that do not allow us to deliver alcoholic beverages.
Okay, thank you. Questions? The conferee, yes, go ahead.
Thank you, Mr. Chair. Just out of kind of curiosity, what other products, consumable products, do you guys sell that requires a specific state license?
So that would specifically be cigarettes, tobaccos, all of our pharmacy medications.
Do you currently deliver those?
Yes, we do with pharmacy.
Consumable products like cigarettes,
No, we
milk,
do not.
eggs, beer. Do you deliver tobacco?
No, we do not.
Can I ask why?
I'd have to do my research, I'm sorry.
Okay, just curious. Thank you.
Good question, thank you. No further questions? Thank you for coming here today. We may have some additional questions later if you remain, but if you need to leave, it's okay.
Okay, thank you.
Thank you. Last up is, that I have today, for this morning, is Tom Palance. Welcome to the committee. We're just all sitting around waiting for your testimony.
I'm sure that's the case. It's also close to lunchtime too, and I get that too. Thank you, Mr. Chairman and members of the committee. I'm Tom Pallas, representing Fuel True, representing the independent fuel distributors and convenience stores throughout the state. And I'm also speaking on behalf of Casey's General Stores and the Retail Grocers Association. They've given me permission to add my comments to with their name. In 2017, the legislature passed Senate Bill 13 and amended the provisions in the CMB statutes, or the CMB Act, to allow CMB retailers to sell beer of alcoholic strength more than 3.2% by weight to 6% by volume. And now, that took 30 years to do. I saw quite a few of those years myself, but not all of them. But it did take 30 years to get that done. And it was a joint effort amongst a lot of stakeholders in the effort to get that passed. But what prompted that was what happened in Oklahoma, where the Oklahoma legislature allowed convenience stores and grocery stores to sell all products, beer, wine, spirits. It also allowed the liquor stores to sell cold beer, because in their statute, Oklahoma couldn't sell cold beer; it had to be hot. So that was their trade-off, and that was passed. So as we looked at what we were trying to do here in Kansas, which I bet we drafted probably over 100 different bills over the years of trying to get this done. But we met with the stakeholders, and if it wasn't for the efforts and the support of the Kansas Association of Responsible Liquor Laws, the beer wholesalers, and the Kansas Association of Beverage Retailers, we would never have gotten it done. So for the convenience stores and the grocery stores, it was a victory just to get it to 6%. That was a big victory for us. Let's go back a couple years to COVID. Of course, you heard what COVID has done with the home delivery of grocery products and what have you, but I'm also finding out that in rural areas, the convenience stores are also doing home delivery of products. So I know Southeast Kansas and Southwest Kansas, two specific areas. I don't think you see it any in the metro areas because of the grocery industry. A lot of times, a convenience store is the grocery store in these small towns. So we too would like to see home delivery, so that when we do home delivery, we could also include beer with that. So you heard about the bill we have for last year. I have spoken with the ABC director, and we are going to work with her on language that she's comfortable with, as well as the industry in general as we go forward. So that is our ask as well. I don't want to repeat all the things that you just heard, but we are very appreciative of what the legislature did in 2017. Granted, it didn't become law until 2019, getting things lined up. But it has been a good effort by the legislature, and it's been good for our retailers in the state of Kansas, as well as the Kansas consumers. So with that, Mr. Chairman, I'll get out of your way.
So what you would like is when I ordered my pizza from Casey's to deliver, they could bring a six-pack of beer, and I don't drink beer, but that's
I've
what
been
you
known
would
to
like.
drink a little bit myself, but I've never had them delivered to my house. But
Okay.
because we can't by law.
But you can call a neighbor to pick it up for you, bring it by. All right. Questions for the distinguished conferee? Seeing none, you must have done a great job.
Thank you, sir.
Good to see you, sir. Committee, I'm going to change the agenda just a little bit. We're finishing up a little earlier than anticipated, but we have a number of written testimonies, and I'll direct your attention to the agenda. People with the Boot Hill Distributing, Union Horse, a couple of wineries. You read that at your pleasure. But we're getting ready to break. I'm going to have Matt, I had him scheduled for 2:30, but it's an issue that I think I need to address now. It's under the Open Meetings Act about what we can do. I know a number of us are going to dinner, and I'm not sure tonight if we have a quorum or not, but I know members are texting between members, and the trouble that you can get into by texting the entire committee. So I've asked Matt to come in and give us a quick overview of the Kansas Open Meetings Act. We surely don't want any violations of that reported. So tell us what we can do as a committee and what we can't. Matt, if you would.
Sure, thank you, Mr. Chairman. So yeah, the memo I just distributed is kind of a wide sweeping summary of both the Kansas Open Meetings Act and the Kansas Open Records Act. So generally speaking, the COMA applies to legislative and administrative bodies and agencies of the state, including boards, commissions, authorities, councils, committees, subcommittees, and other subordinate groups that receive or expend public funds and that are supported in whole or in part by public funds. COMA generally applies to legislative committees and subcommittees unless House or Senate rules create an exemption. For instance, the House and Senate rules create an exemption for caucus if it's so necessary. So what does the COMA require? COMA requires meetings to be open to the public, that notice of the meetings be provided if requested. It's broadly interpreted to achieve its purpose of facilitating an informed electorate. If questions arise over whether there's been an issue, the Attorney General or the District Attorney may investigate and then examine the specific circumstances. Then if you look on the second page, it kind of walks through situations of what does a meeting mean, what constitutes a meeting, because sometimes these things can happen really innocently. The chair has Jordan, when you respond back to Jordan, everybody it's blind carbon copy, because we don't want to create a situation where you have serial communications where one member of the committee says something and then another responds, and then you start getting this back and forth discussion that sure feels like a meeting when you're talking about committee business, and you're not doing that in the open. So we want to avoid circumstances like that. Other instances are when, if this body or any body is out at a separate event outside of this building, there's nothing wrong with that. People can gather. But the discussion of committee business by a majority of this committee or any committee outside of a public forum then runs a risk of violating COMA, because now you've got a majority of a committee that can take action and they're discussing committee business. That creates the potential for a COMA violation. So that's also covered in this. Rather than run through each specific, I'm happy to kind of answer specific questions individuals might have, but that's the general gist of COMA.
Thank you, Matt. And the reason I wanted that, because one, that we do have a dinner tonight, and I'm not sure the number that are attending. We may have a quorum, we may not have a quorum, but also in the last session, there was some committee meetings where the committee was texting and people were responding, and they were responding to all, and those were a violation. And we're just trying to avoid that. So you can speak to individuals, but you can't have a quorum on that. So I just wanted to remind everybody that if you get a text from a group or the committee or from Connie, it'll be just about the agenda and not about specifics. And I would like for you not to respond about specifics on anything that we've heard. Any questions of Matt?
And that's a very good point, that a lot of this happens or can happen very innocently. The idea is that you're just talking to people, but it's a good rule of thumb to kind of step back and wait a minute. Does this involve a majority of a body? And are we talking about any business that's in front of the body? If that's the case, you don't want to do that unless you're in a public forum.
Exactly. So, thank you, Matt. Any other questions of Matt, if there is any? Seeing none, thank you again, Matt, for that update. Just to keep us all mindful of what we need to be doing. Folks, we have finished the morning docket, the morning agenda. So we're going to take an early lunch, which I know upsets most of you. But we will reconvene at 1:30. We have a number of conferees, and hopefully we'll adjourn possibly a little early, and if we do, I know the Kansas Beer Wholesalers has invited the entire committee out for dinner tonight. If you've not responded, please contact Connie and join us tonight at the Country Club. With that, if there's nothing further for the good of the committee, we're adjourned till 1:30.
How have you been?
I'm getting Okay. Debbie, are you on? I see the DB.
Yes, Mr. Chairman, I am on.
Yes, I think you had some clarification for us. That was
Yes.
in, okay. Go right ahead. As to the adjoining county.
Yes. Sorry, I had to turn my volume down a little bit. So KSA 41308 specifies the rights of a licensed retailer. And subsection B2 says that a licensed retailer may sell and deliver alcoholic liquor or CMB to a caterer or the licensed premise of a public venue, club, or drinking establishment if such premises is located in the county where the retailer's premises are located or an adjacent county for resale by such on-premise licensee. So nowhere else in the statute does it authorize selling to an on-premise licensee. You wouldn't sell to the premise, you sell to the licensee. So ABC views that and interprets that as two different things. One, selling to the on-premise licensee, and the other is delivering, provided that they're in the same or adjacent county. Now, it would be our preference if that was a little cleaner, but clearly there's two things going on in one sentence, selling and delivering. I also would note that in the last sentence, it's missing the word drinking before establishment, and that should be cleaned up at some point. It's a technical issue.
Okay, Representative Long, did you have a question?
Thank you, Mr. Chairman. So this is your interpretation, Debbie, right? I mean, this is in conflict of what Jordan told us this morning?
No, this is consistent with what Jordan said this morning.
Okay.
Okay.
So to paraphrase you, drinking establishments can purchase liquor in a county that is not adjacent for resale in a drinking establishment as long as they pick it up and it's not delivered?
That would be correct.
Okay.
Okay.
Well, our point of contention is that I think
I'm going to stop you there because my revisor may have a conflicting report. Matt, if you give us your interpretation of it.
I should have actually taken him up on that offer. So thank you, Mr. Chairman. So I definitely understand that interpretation, and that may be what everybody wants to get to. In reading 308B, I have to start with B before I get to paragraph 2. And it says, a retailer's license shall permit sale and delivery of alcoholic liquor and CMB only on the licensed premises, and shall not permit sale of alcoholic liquor and CMB for resale in any form, except that a licensed retailer may. And then we go into 1 and 2. So you start off with can't sell for resale. Then you go down to 2 and you say sell and deliver alcoholic liquor and CMB to a caterer as the director has laid out. When I read that, that seems to indicate that an exception to that no sell for resale is you can sell and you can deliver alcoholic liquor if the premises are in a county that is the same county or an adjacent county. So reading that, I would say it's at best unclear, but I'd be concerned in reading this that my reading of it is saying that exception only applies if it's in a county, the same county or an adjacent county. And outside of that, then no. Part of the confusion too could be our use of the word deliver. Historically, as I know Mr. Duncan can wax poetically on this, historically, deliver is, the actual act of giving something, not necessarily shipping and delivering. It's the actual transfer from one individual to another in an intentional legal manner. So some of this could be old language that's adding to the confusion. So at the very least, whatever the direction is that people want out of this, whether you want it to allow beyond an adjacent county or not, there may be clarification that would be a good idea.
Representative Long?
Thank you, Mr. Chairman, and thank you, Matt. I think at best today, this is a confusing issue. So I think that's part of the premise for having this committee to look at these sort of things, and this is one that's come up, and I would suggest that this committee talk about clearing up this language in a bill next year and making it more apparent what the law really is intended to do. Thank you.
Thank you. Representative Kessler?
Thank you, Mr. Chair. So what we're saying is that there's a kind of a conflict between the handbook for ABC versus what our actual statute says.
I would definitely defer to the director on the handbook. I was shown it, but I'm not very familiar with it.
I'm reading right now directly from the handbook, and it clearly says that they can buy from a non-adjacent county as long as they pick it up.
So my understanding is that that's the interpretation that ABC has had, and what I'm offering is that I have concern that the way I read the statute is a little different. I'm not, the end authority on that, but my reading of it is concerning when I read those provisions together, that maybe it doesn't authorize that.
Thank you.
Thank you. Further questions? And that's an issue that when we make our recommendations, Representative Long, you may want to make that recommendation that we have some clarifying language in that area. But if there's no other questions of Matt or Debbie, we're going to move on.
Can the other question that came up earlier as well?
Yes. Go ahead.
So,
that was Representative Tarwater's question.
Yes, when we were talking about farm wineries, and I think in my haste, I combined two provisions and rather than expediting and adding clarity, I confused it. So if you look at 401-308A, subsection A6, the sale of wine manufactured by a licensee for consumption on licensed premises, provided the premises are in a county where the sale of alcoholic liquor is permitted, is allowed for a winery without a CDE license. They can sell their wine on their premises if it's allowed. Now, if they want to sell alcoholic liquor as well, they need to get a CDE license.
Was that helpful, Representative Tarwater?
Yes, that's helpful. Thank you,
Thank you.
Mr. Chair.
Any other questions as to that subject? Seeing none. Thank you, Matt. As always, we do consider you the ultimate authority. At least in committee. Next up, we're going to start taking conferees. We have our next conferee, someone we all know, has been an alcoholic for years.
Probably some truth to that.
All right, Mr. Tuck Duncan. Tuck, we will give you the floor.
Thank you, Mr. Chairman. I'm not going to address all of the issues that you mentioned at the last meeting. I'm going to try to clarify a couple points that came up yet today. If you make some modifications to the Liquor Control Act as it relates to that issue, part of the confusion is probably because there's nothing in the Drinking Establishment Act relating to where the on-premise licensee can purchase. So you may want to have a corollary in the Drinking Establishment Act about where they can purchase. Then there won't, because currently it's silent, and under 41-104, unless the legislature authorizes something, with certain exceptions like complimentary serving of wine at political functions, doesn't require a license, in case any of you are running for office and need to know that, it's prohibited. So it's very important. So if it's silent, it's prohibited, and that's why you might need some authorization. That might clear that up. Secondly, with regard to this whole issue of farm winery zoning, I would suggest that Representative Tarwater look at Attorney General's opinions 96-86, 92-92, and Kansas statutes annotated 19-2921. It all centers around what the hell is an agricultural use. And the statute makes it clear, because we are an agricultural state until the next reapportionment. Sorry. It says that except for floodplain regulations, regulations adopted pursuant to this act shall not apply to the use of land for agricultural purposes, nor for the erection or maintenance of buildings thereon for such purposes, so long as such land and buildings erected thereon are used for agricultural purposes and not otherwise. So, if a farm winery can have a DE, and a farm winery by definition is an agricultural purpose, my old algebra, if A is B, B is C, therefore, does that mean that the DE does not have to conform to certain regulations? I don't know the answer to that. Maybe the Attorney General could tell you. I'll give you these.
Okay. Based on that response, Representative Tarwater?
These items you just handed me, these are the Attorney General's
The two AG opinions and the statute.
and they state that
They
they
talk
don't
about
need,
what an ag purpose is. And it's one of them specifically says a farm winery is an agricultural use.
so there wouldn't be additional codes to get
Well-
a DE, in their opinion.
I think that's a reasonable reading of that. That would be my opinion, but I just litigate stuff. I'm not a member of the Board of County Commissioners of a county.
Thank you.
But it's a place to start. That's all I'm trying to say.
Appreciate it, thanks.
The other solution is we amended the producer's license last session to make it very clear that the producers, who are definitely ag, they're just growing grapes, could have a CMB license, and once they issued it, the senator will remember this in Fed State, they have to grant the license. So we have a template for handling that if this doesn't take care of it, if that's what the committee's desire is. So.
Go ahead, Representative.
So is a farm winery also a producer, being that they grow their own grapes?
Farm winery is not a producer. There's a separate producer's license for people that grow grapes or honey or berries, send it to a Kansas farm winery who makes it into a wine and sells it back to the producer, and then the producer's allowed to sell that wine at their farm. And if they get a cereal malt beverage license, they can sell beer too.
Okay, so when that law was last year or 2 years ago, maybe?
Last year.
And then.
This year, actually. My years are
Yeah,
all.
we didn't, then, I had thought that we had allowed the farm wineries to have a CMB license at that point, but that was only for the
I don't
producers.
think we granted the farm wineries a CMB license separately because they can already get a drinking establishment license and sell all the beer they want.
Okay, great, thank you very much.
I mean, that's a separate issue, though, relative to the zoning.
Okay, Tuck, I would ask that those AG opinions and the statutory be sent to Jordan so that he could send it out to all the committee members?
I can do that.
Thank you.
I can do that. None of that is my testimony. I want to talk, I have a request. The request is that at such time as the committee decides what it wants to do, since this is a little atypical, we don't have a bill in front of us, I don't have something I can look at and say, gee, I don't like this or I like that. If we could have the opportunity to come back and comment on it, that would be greatly appreciated. Once you decide we're going to do this and this and this, then it'd be nice to have an opportunity to come back and be a little more specific about what it is. I want to give you a 20,000 or 30,000 foot look at the liquor industry very briefly. And then, Mr. Chairman, I went and pulled out my old paper about franchise protection. It may interest you to know I have done continuing legal education courses all across the United States. I've done them for the National Association of Alcoholic Beverage Control, the control states, and that at the NCSL and the like on this issue in particular. So this is an issue dear to my heart because I'm the guy that wrote the brief to the U.S. Supreme Court when we first passed the franchise law in 1979, and the Supreme Court, based, of course, I'm sure it was my brief, decided not to take cert and upheld the Kansas court decision, finding that the Kansas franchise law is constitutional. So I've been with this issue for a long time, and I will talk
And I
about
have
that.
great appreciation for that. Just to let you know, we're having one more meeting. At the next meeting is when the committee, based upon all the testimony, will go through those questions that we had the reviser and the research people go through, and I will look for things that we may want to recommend. And remember, we're only recommending to the legislature that either a bill be drafted or probably the lesser of those would be that we would recommend that the appropriate committee further look at that issue to see if it's something that we would want. So
I'll be back in January, and it's good to know I have employment for another year.
right.
Thank you.
Until there is a bill, you're correct. We can't really analyze it. But the committee is only looking at, and my task when the speaker asked me to chair this was just look at some of the things that some other states are doing, and if they're good for other states, maybe something we want to move here. You know, you've been around a long time, but I remember when we used to have the little stamps when you went into a bar to get a drink, and that goes back, I think, to the 70s. It could have been the 60s. So things have progressed, and this is a modernization. And the populace, they've changed. I mean, people shop or they don't shop. They shop at home. And we've got to look at those changes that will help the younger families and stuff that may have 3 or 4 kids at home, and the mother never leaves the house. She does all of her shopping, all of her clothes, all of her groceries and everything, and have them delivered to the house, or she drives by and they put them in her trunk and she drives home. But with that, I just want to let you know there is another meeting, and that's when we will make those recommendations. But with that, I didn't want to,
No. So from the 30,000-foot perspective, I want to very briefly, we have a thing called the 21st Amendment. The 21st Amendment says the states get to write the laws. Now, our U.S. Supreme Court has kind of eroded that a little bit in recent years because the committees will be familiar. We did away with residency because 2 years ago in Tennessee, the Supreme Court found that durational residency requirements are unconstitutional. 12 years ago in Grandhome, a case out of Michigan relating to wine shipping, the Supreme Court said if you extend to somebody in your state a particular privilege, like shipping, you cannot give that privilege to the out-of-state party. So we need to be at least aware of unintended consequences on things we think innately, this is a great idea. Because sometimes a great idea can have an unintended consequence that will undermine the rest of the system that you have so carefully put in place since 1949 when we repealed Prohibition. And we do that to uphold what's known as the police power, to protect the public health and safety. And it is a little different still to be delivering, vegetables as opposed to be delivering a beverage that persons under 21 are by law not allowed to consume. So there are rationales for having certain types of regulations. If the committee decides to move forward on that issue, that's not a wholesaler's issue at this time, then, all I'm saying is orderly market. That is the key. The key is ultimately we have regulations to preserve an orderly market so we don't have abuse within the by the general public, because we do have a lot of regulations. So in my testimony, I go over a few topics. I talk about the direct-to-consumer shipments of spirits, which was one of those that was brought up. I believe it was brought up primarily in the context of somebody in Kansas goes to a Kansas distiller, and that Kansas distiller wants to then ship it back to somebody who's halfway across the state, and currently they can't do it. If you give a Kansas distiller the right to ship something to a Kansan, you are opening the door for every distiller in the country to ship to a Kansan under that Granholm case. You cannot prevent the out-of-state guy from doing it. Now, why is that a problem? It becomes a problem because you may recall last session you passed what's known as the Fulfillment House law. Fulfillment House license was because we found out in Kansas a year ago we had 198,000 shipments of product, just supposedly wine, to consumers. 198,000 shipments in a state of 3 million people. This is just 1 month's worth of those shipments, small print, by either FedEx or UPS. We went through all of these and we found out that 68% of those shipments by FedEx were from persons who didn't have special shipper licenses. They were either from retailers, they were from distilleries, they were from all sorts of people who were not authorized. What's that mean? They didn't pay the gallonage tax. So if we're losing 30 cents a bottle gallonage tax on wine, can you imagine how much we're going to lose if and when, if we don't have a system in place that's going to protect us when the tax is 8 times that? And so one of the things I implore you to do is don't move too quickly. Let's see how the Fulfillment House licensing gets into play. Let's see how the shipments clean themselves up and how the taxes get paid. There is another issue, particularly with spirits, though, that could be problematic for Kansans. If you allow out-of-state direct-to-consumer shipments of spirits, there will not be those very, very allocated products on the shelves in Kansas, and they won't be in our restaurants. And they won't be there because they'll sell them directly to the consumer, and we'll never see them. Some of these products, we get 2 cases a year, 24 bottles for 750 stores that we got to figure out how to sell, because that's all the 3 million people in Kansas are entitled to from limited production. So they won't sell 2 cases to us. They'll sell all 24 of those bottles directly to the consumer, keep all of that margin, and avoid the 3-tier system. So you're going to have real consequences relative to selectivity of product on the direct-to-consumer if you move in that direction. But I think the best way is to see what happens with regard to the Fulfillment House license before we. If you know of a Kansas distillery that is not in general distribution in this state, let me know. I will find a wholesaler to sell that product to your local retail store. And then anybody that wants to buy it can go down to their local retail store, order it from that retailer, and have it delivered to them through the system. So if that's the real issue, we'll figure out how to do that. We can do that. I've got 5 wholesalers, member of my association, and I'm sure they will be glad to sell Kansas products. I know they sell Dodge City stuff and all sorts of people stuff today. So I really think that's a problem. And then let's talk about ready-to-drink tax rates. The question was, can we reduce the taxes on this new phenomenon known as ready-to-drink? I've often said spirits are a concentrate and beer and wine are mixed. You can open the bottle of beer and wine and drink it right away. Spirits, sometimes you might want to put it over ice or add some water or maybe some soda pop. I don't know what a ready-to-drink is. I know that canned cocktails are the big thing. I know that those products are just hitting the marketplace tremendously. I have a chart here showing, High Noon, which is a spirits seltzer sold by E&J, sold 3 million cases in 2020. This stuff is huge. My concern is before you just automatically say we're going to reduce this tax rate, I want to know what the unintended consequences of that are. You will lose taxes in that category. And I don't want to shift those revenues to some other, because you'll be back asking the industry, well, we gave you so much back, now we got to have this much to replace it. So we need to figure out what is the real consequence of that. I did give you a couple examples of things that you could do, though. I gave you the Nebraska example. They have a bill pending up there, and I gave an example of Arkansas. Arkansas has a bifurcated system depending upon the proof, or the proof or the percentage of alcohol, you pay a different tax rate. And so those are a couple of examples. And what is a ready to drink? Is it the gin and tonic that's in the can that I can buy on Delta as I fly to Louisville tomorrow night? Or is that the ready to drink? Is it the seltzer? So I don't know, which are infused with spirits, or is it the old Bartles and James wine cooler? Is that the ready to drink? I mean, we used to have a Seagram's spirits cooler, and they converted it over to a malt-based alcohol because of the taxes. Instead of paying $2.50 a gallon, they now pay 18 cents a gallon. So there's a lot of complications to it. It sounds great, and I'm not against reducing taxes, and if we don't have to pay any taxes, that's even better, but there are unintended consequences. And then, two final topics. Recodification. I believe my colleague over here in the law suggested we may want to recodify. I don't know if we really want a 1,000-page bill. The problem with recodification initially is most of the people look at the bill think it's all new law. They don't realize that the only new law is the stuff that's underlined or struck out or italicized, and they start reading this stuff, really, that's it? I've sent to you folks previously a study I did. It seems like there's only 7 or 8 statutes out of the whole Club and Drinking Establishment Act that have references back to the Liquor Control Act. The solution here is put those definitions in the Club and Drinking Establishment Act. If there's confusion, then I suggest people hire a lawyer who needs the business, and he can help clarify those things for them. So that would always be a full employment act for lawyers. I don't think there's confusion. We have the handbooks. The handbooks are plain English. They explain most of what's going on. And maybe once in a while we have 1 or 2 subject matters that aren't exactly correct, but nonetheless. So I would implore you not to journey into a full-blown recodification, but you could, eliminate the crossover. All right, let's talk about Kansas franchises. Kansas is not the only state to have a franchise law. Kansas was prophetic in 1979 when it enacted its franchise law because we have one law covering all 3 categories of products, beer, wine, and spirits. In many states, they have, if they have a franchise law, and I'm not saying they all have one, but if they do, they have one for wine and spirits, and they have another one for the beer industry. And almost every state has a franchise law for beer, but they don't all have them for wine and spirits. So when we looked at this back in 1986 at the Liquor Law Review Commission, my good buddy, Mr. Whitaker, who was then the head of the Kansas Beer Wholesalers Association, I sat down and said, why don't we just have one law for everybody? Your people are going to be selling wine and spirits. Our people are going to be selling beer. Why don't we do that? Because in that time, we created 3 separate licenses. And if you were a distributor, you could have a beer license, or you could have a spirits license, or a wine license, or you could have all 3. And that's what we did. We created the Kansas franchise law. And it's been in operation for 42 years with very little, if any, difficulty. And in my recollection, I can only think of 2 cases that have been litigated. And they were district court cases. None that I know of have ever gone to the appellate court level. And so you asked earlier, what is reasonable cause? Well, reasonable cause is just cause or is good cause, depending upon which statute and which state you're reading. We have an Attorney General's opinion, 88-41, and it said, it asked the same brilliant question the chairman asked. Where do we go? Where does the judge look? How do we find out what that means? And the Attorney General said it's very simple. The Kansas franchise law is akin to the franchise laws that we have for automobile dealers, or the ones that we have for farm implement dealers, or the ones that we have for certain sports dealers. I mean, this is not the only franchise law in Kansas. We have them for a whole variety of industries. And so it said, if it's silent in our statute about that, look to the other statutes, and that's where the judge starts, because we have a theory in law or a principle in law in para materia. when the legislature defines something in one section and has not, then you go look at what that similar definition is in other sections of the law, because obviously the legislature knew what it was doing when it enacted that law, and it intended that it have the same type of definitions as the other laws. And so that's the answer. We know what reasonable cause is, and it's generally, as set out in the statute, things such as bankruptcy. If a wholesaler goes bankrupt, that's a reason to terminate. It's called a franchise law because franchises are where people make investments in the brands of another owner. So when a wholesaler takes on, Dunkin' Bourbon to sell it, he goes out, he puts salesmen into the marketplace, he gets it on the shelves, he takes it to the stores, he promotes the product, he does sampling, he has an investment in that product. And the reason that you cannot just summarily say, goodbye, Mr. Wholesaler, and have to comply with the rules of 41-410 is because that investment has been made, and it would be patently unfair to make one guy make all of that investment in the promotion of that product to the detriment of and to then benefit another party who did nothing, just on the whim of the guy who owns the brand label. And so these cases, you have 30 days to file an appeal in the district court, and if you want to duke it out, you can, but there's not been a problem in Kansas. 42 years, no court, that's why you couldn't find a definition, Mr. Chairman, because there haven't been any cases. And that's because the wholesalers in this state work well with their suppliers to make sure. Now, why did I say at the start of this was prophetic? It was prophetic that Kansas put wine, beer, and spirits in one law because back in '86, I wore my Seagram tie today. When I got this tie, it had a little label, not to be worn by anyone under 21 years of age. We used to have Seagrams. We used to have a whole lot of suppliers that we don't have today. In fact, suppliers that were here 40 years ago are not even here anymore. They've been absorbed by others. They were single category suppliers. They sold spirits, kind of like Sazerac sells a lot of bourbon, and so they were single. Well, that's not true today. E&J Gallo, the biggest seller of wine in this country, sells spirits, New Amsterdam vodka, High Noon seltzers, and they have malt products. Constellation. I mean, there are a lot of great suppliers out there who now sell all these categories. So splitting it up and having a franchise law for only one category or two and not all three categories really would be counterproductive to the fact that the modern day business model is that you have a few suppliers and not major suppliers who carry all categories. One of the things in your I don't know if that totally answers your question, Mr. Chairman. I do want to make a comment about the purpose of this committee. One of the things was to say we want everybody to be equal. We have not treated these different categories of products equal since the repeal of Prohibition in the 30s. We don't treat spirits the same as we treat beer, as we treat wine. And maybe I should be here saying, please do that, because then you'd be reducing my $2.50 per gallon spirits tax down to 18 cents, which is what the beer people pay. We don't do that. We don't do that because there are some very bona fide, justifiable, orderly market reasons that these three categories exist. And so we have, so that's, and finally, there really are no barriers to getting involved in business in Kansas. We have some of the cheapest license fees of any state. $250 a year, it's a 2-year license, so $500 for a retailer. $2,000 for a 2-year license for an on-premise establishment. CMB licenses are $50 or $75. Nobody has a problem acting as a financial barrier to getting into this marketplace. But what we've discovered is this marketplace will support 750 retailers in this state. You know why I say that? Because we've had 750 retailers literally for 2 decades. Yeah, new ones go in, old ones go out, but that's the market. The market is 750 retail liquor stores. 22 counties have 1, another 22 counties only have 2, so I'm sympathetic to your problem about being able to get product in certain areas. And then the rest of the state, we have more than that. So that's the 30,000 view of the system, maintaining an orderly market with some commentary on a few of the things that you brought up last meeting, and I hope I've responded to your inquiry, Mr. Chairman.
Thank you, Chuck. And again, would you send to Jordan that AG opinion that you cited?
Yeah, I have it right here.
Okay. Give it to Connie, and we'll get it out to the committee. Thank you. Questions for Mr. Duncan? Yes. Representative Carmichael.
I better get my asthma medication before I start with Mr. Carmichael.
Thank you, Mr. Chairman, and I apologize to you and the committee for my absence before lunch. I had another committee hearing where I had to do some real substantive work, so thank you for allowing me to be excused.
Are you saying we're not doing? No,
You do understand the implication I intentionally made, yes.
You had given me a heads up, and I appreciate it.
And thank you, though, for your courtesy. It was important I be gone. Mr. Duncan, there are three questions, I think, or at least three areas that I have for you. First, with respect to recodification, perhaps during our last meeting I slurred my words. I can't remember whether it was before lunch or after, so maybe I did not speak clearly. But I thought that I asked, should we recodify as opposed to advocating for recodification? If you really want to know
My mistake.
If you really want to know my personal opinion, we'd be better off to look at that 10 or 12 areas that you've just talked about rather than rewriting it, because it opens a whole can of worms that we'll never get the lid back on if we try to recodify. That's my free opinion. You did mention the Granholm decision, and you gave us information probably in the context of the wine and spirits folks about a distillery wanting to ship from, say, Dodge City to me in Wichita. I'm not going to say what I have to say about their product. And that would perhaps open the door for distilleries, perhaps in other states, to ship into Kansas. Elsewise, we'd be favoring our local distillery as opposed to a cross-border. If I were to ask you, though, in the context of CMB, let's say that our friends from Whole Foods or Dillon's obtained legislative authority to deliver CMB to my house, would that also then require that we allow a grocery store across the state line to, in essence, import CMB into Kansas and deliver it to my house?
Not if you adopt a bill that makes it clear that whether it's the retailer, the grocery, convenience, Dollar General, bait store, whoever that's selling that CMB, delivers it only within the county or city in which they're located. And I say county and or city. Those are definite geographical areas because we have some cities that are in two counties. So you could have a liquor store in a particular city who could then deliver to either of those counties. But so if you do that, I think the bill that was written by Mr. O'Neill's folks basically has a mileage distance. We suggest the mileage, in my judgment, creates a problem across state borders, because how can you divide? If you confine it to those areas in which they are locally licensed, then I think you avoid the dormant commerce clause. Another reason you avoid it is you're going to be licensing these people and you have jurisdiction on them. So you're going to make sure they have a permit so you can yank it if they deliver to a 21-year-old. You're going to make sure that they have a valid driver's license and that they are insured. We have 10% of the drivers in this state have no insurance. And so you're going to make those sorts of requirements. And under the Tennessee case, Justice Alito made it very clear that states can enact certain types of regulatory requirements to protect the public with regard to consumption and those issues. Final comment is, shipping and delivery are two different matters. Delivery is the process of taking it from the location where it's sold and taking it to the third party at some nearby geographical. Shipping is wrapping it up, putting it in that Priority Express envelope, getting some postage on it, or putting it at FedEx and having it sent halfway across the country, basically by some third party person who has a permit to handle cartage.
I don't want to take too much of the committee's time, and perhaps you can educate me at a later time, but why wouldn't the same concept be applicable to drawing a law that says a distillery can ship within the state, and by somehow so doing under police power, regulation of alcoholic beverage, et cetera, limit that to in-state distilleries can't cross the state line? I'm not tracking why it would be different for CMB coming from St. Joseph, Missouri to Atchison, Kansas.
Well, a unique thing about beer, and yes, I'll sit down with you. Let's go through it. I'm always trying to get to yes. A good lawyer always tries to get to yes for their clients. They don't pay you if you tell them no, as a general rule. So we'll try to help get
and
to
that's why
yes.
some bad lawyers have lost their license. They failed to tell their client no. So okay.
If we could get there, I'll work with you. The beer thing is a little unusual. You need to remember, we have, I don't know, 30-some beer wholesalers in this state. They have franchise agreements for exclusive territories by county. Some beer wholesalers only have one county. So that beer wholesaler sells to that retailer, that grocery store in their county. They don't want that grocery, the guy who has the franchise right next door to deliver that beer doesn't want the guy in County A delivering the beer to his competitor's beer across county lines to somebody else in another county. So you're going to have a supply chain problem because of how the beer system all works in terms of delivery and franchise laws and exclusive territorials.
Thank you, Mr. Duncan. I'm glad I did not have to pay you for your time, and I've asked enough questions, Mr. Chair. Thank you.
It's all about billable hours. But our time is running.
I'm sorry, I didn't mean to take up so much.
No, it's always helpful when you appear and look at the overview at, what, 30,000 feet or whatever your statement was. But we are going to move on. I'm going to take up next conferee is Amy Campbell, Kansas Association of Beverage Retailers. Excuse me. Amy, welcome to the committee.
Thank you, Mr. Chairman. I don't necessarily like following Tuck because then my brain is all scrambled when I get up here, but I'll try to get back to kind of a orderly presentation of my testimony. My name is Amy Campbell. I work for the Kansas Association of Beverage Retailers. This association was created in Kansas at the repeal of Prohibition. It represents the Kansas retail liquor stores across the state. All of our members right now are Kansans. You are aware that last session, Kansas was forced to change its residency law based on some court decisions that had taken place. So we look forward to maybe having some non-Kansas members at some point in the future. Every change in our statutes does have an effect on current liquor store owners and their business viability. Please remember that our owners are still dealing with the aftermath of the 2019 beer law. That law shifted a significant portion of beer sales to grocery and convenience stores. We did support that compromise, and we still believe it was the right thing to do because it separates the retailers based on the alcohol content of the product. According to the Division of ABC website, Kansas now has 38 fewer licensed liquor stores than in 2017 when the bill was passed. Mr. Duncan told you that Kansas supports 750 liquor stores. We now have 721. So we are seeing stores go away slowly. We believe that this has been a slower attrition than what was expected due to 2020 and the COVID pandemic. That provided a temporary boost to some of our stores as the wine and spirits buying was temporarily shifted away from clubs and restaurants into our retail liquor stores. If you look at the tax sheet that was distributed earlier today, It shows that the drink taxes, which is what your clubs and restaurants paid, went down 0.1% for the period covered. So they've recovered pretty well, considering how far down that was late 2019 and to 2020, whereas the liquor stores had 9.7% increase in the taxes we paid. Jump forward to the first 2 months of this fiscal year, and we're down 5.3%. So you can see that that shift is occurring. The restaurants and clubs are up 51.4% in those first 2 months. So we anticipate that change. We support the reasonable business-friendly regulation of spirits, wine, and beer, and we really are always anxious to talk to all of you about any public policy changes that you recommend for our industry. As you look at your list of ideas for changing the liquor market, please keep in mind that the healthy industry that you see today and the myriad of effects that come when any part of that system is altered rely a great deal on what the legislature decides. If you authorize more entities, especially unlicensed entities, to enter the Kansas liquor marketplace, you are diverting from the licensed businesses that are in that market today. While many states have rushed into alcohol deregulation, Kansas has always been more careful. And as Debbie Beavers testified to at your last meeting, Kansas has rapidly expanded the number of entities that are selling and serving alcohol in Kansas. She's also spoken to you several times about the struggles to enforce state laws relating to accelerating shipping of wine into the state, often from unlicensed entities. Her testimony covered this growing challenge of online sales and also about counterfeit products. We hope you will be attentive to these problems and provide them with the resources they need to enforce our laws, as well as avoiding new laws that could worsen that challenge. You don't have bills in front of you, so I'm just going to touch a little bit on some of the topics that have been raised. Direct-to-consumer delivery. I know that Tuck gave you a lot of reassuring talk about how that can be done. Theories are theories. There is some early case law that seems to support some of the concepts that he's put in front of you. But we have been researching models of direct-to-consumer delivery for several years. I have gone to national conferences and spoken to retailers in the states that allow direct-to-consumer delivery to see if that is something that we wanted to jump into. At first, it looked like a promising model. There could be some good ideas out there. But here is the problem. While beer and liquor delivery sounds simple, a simple online word search can show you just how complex this field has become. The online platforms that are supposed to be set up as an agent of the retailer turn into the dominant entities that expect a significant fee without holding the risk or the regulatory burden. Their growth is crowding out the smaller competitors and turning the retailers into an agent of those online platforms. Independent retailers have a significant disadvantage attempting to compete in that environment. At our recent national conference, I spoke to an entity, I'm not going to say their name, but they were selling to the retailers, hey, join our group, and we have a powerful online platform, right? What they were selling to these retailers was, you will be invisible. The customer will never know it comes from you. They will deal with us. We'll set the prices. We'll make sure that FedEx or UPS makes the delivery to their home. Why do they even need the retailer in this environment? Because that platform is not a licensed entity. They have no license. They have no regulation. At such point, as they get the opportunity to bypass the retailers altogether, we can be assured that that will be the business model and that the retailers will be cast aside. We continue to research these changes that occur across the nation, and we are very aware of how important delivery is in the future and to what consumers expect to see from retailers. But we are asking you to sit back and let the dust settle in some of these other states, and let's see if anyone comes up with a model that is workable, one that does not simply result in the consolidation that we've seen in other types of online retail. As it relates to direct-to-consumer shipping, we are very concerned about adding distilleries to the shipping provisions of Kansas law. Our supply chain problems are significant and real. The products that were hard to get 2 years ago are now much harder or impossible. Shortages of everything from glass to aluminum to workforce have compounded this issue. On top of that, Kansas is already having difficulties tracking down where the wine shipments are coming from and whether or not those entities are licensed anywhere. If you look at the 2021 ABC annual report, the director reports to you a sting that they did, where they ordered shipments from online, and how many were willing to ship illegally and were not licensed, not only not in Kansas, but also not with the federal TTB at all. And as far as checking IDs on those deliveries, that was non-existent. You know, I understand that sometimes when we talk about checking IDs, legislators sit back and think, well, why is that such a big deal? If it's not a big deal, then we need to spend another special committee sitting around trying to figure out how to get this out of all of our on-premise and off-premise statutes for the retailers in this state. Overall consumption of alcohol has increased phenomenally during this pandemic. I have cited 2 studies in here for you just because I know this was a topic at your previous meeting. I don't cite this to you to say that we don't want to sell to our customers. We do, but we want to have our adult customers for a lifetime. We want them to be healthy and responsible users of our products. If you read the studies that I've cited in here today, you can see that the increasing alcohol use is having serious public safety and health effects on people. And I would note that the criminal report that you got earlier did not include our largest counties and did not include what is going on in the state since you passed the expanded access to alcohol laws that have been passed. With that, Mr. Chairman, I want to thank you for the time. I hope that I've spoken about the topics that you all were very interested in. Our liquor stores are passionate, family-owned businesses, and they are always happy to come and visit with you as well. Aaron Rosenau, who owns Fern's Retail Liquor, will be here tomorrow to speak to you. Thank you, Mr. Chairman.
Thank you. Questions for the conferee? Go ahead, Representative Tarwater.
Thank you, Mr. Chairman. I had a question regarding the 38 liquor stores that went out of business since the law passed. When did the law become effective?
It was effective in April of 2019, but we did have some older liquor store owners who decided between 2017 and 19 that they weren't going to stay in this market.
Okay, so how many of them actually went out of business since the date the law took effect?
I'd have to go back and look at that. Actually, I think I do have their report. But, I mean, the majority would have been since 2019.
Would you get that information to the committee, please? I'd like to know how many liquor stores went out of business each month since the passage of that law.
Okay, I'll have to ask the ABC.
And how many liquor stores rebirthed since that law?
I'm sorry, how many liquor stores were?
New liquor stores formed.
So this number includes all liquor stores.
Great, perfect. I'd like to know how that affected the marketplace.
So what we've seen is that, and this is particularly true for some of our older members, right? They put their store up for sale because they didn't want to go into this new marketplace. They didn't want to compete. They knew that their store was mostly beer sales, and they didn't feel like they wanted to go into that market. And then they have trouble finding buyers because the forecasts were dire, right? So some of those ended up just selling their building, but they end up relinquishing their licenses and going out. We have several members that were good members of mine who had to close because they were leasing their space from a corporate entity. Sam's Club shut down their liquor stores that were leasing attached to their properties, so they didn't really have a choice. They were just told to leave. So you have a variety of reasons for sure. And yes, I'll go to the ABC and get that on a month-by-month number for you.
That'd be great. And if you could also let us know, you said that the beer sales went down in the liquor stores. I'd like to know how the sales for tobacco sales have done in liquor stores and how the sale for mixers and ice, the 20% that Bill had in there to allow liquor stores to compete with other marketplaces. So I'd like to know how the sale of tobacco is going, how the sale of that 20% that we allowed of sales. Are they offset by the beer losses, or is it greater than the beer losses, beer sale losses?
So here's what I will commit to you, is that I will do a survey with our members and probably won't have that information back until before you guys meet again, but I will absolutely do a survey and see what we can get on their individual numbers. You don't have any way to use state records to quantify that.
Would we have state records that would have sales tax collected for tobacco in liquor stores?
I would imagine the Secretary of Revenue has that.
Maybe we could have staff look into beer sales,
I'll have
the
Jordan.
the decline of beer sales versus the
increase.
the increase in tobacco and other sales in liquor stores.
Okay.
So I would just point out that your statistics, the sales tax number that I as a liquor store have if I was operating a smoke shop and a liquor store. When I consolidated all of that, you see what I'm saying? There won't be a different number to look at for me after the law, but we can look at the dates and hope that that shows some difference.
We'll get that information.
And I'll be surprised if the Department of Revenue has that number for liquor stores selling tobacco, but we can sure ask.
All right.
Thank you. Thank you, Mr. Chairman.
Thank you. Other questions? Yes, Representative Carmichael?
Thank you, Mr. Chairman. By the way, I appreciate the chairman's questions about that. I would certainly hope that we would have our staff make those inquiries, because I trust Ms. Campbell as I do the Lord himself, but it might be better if we get that information through our staff and from ABC and Revenue directly. It might carry more weight, just my thought.
I understand it, Ms. Campbell. I know the representative, and do not take it for granted that he does that.
If I might turn, though, to a couple of substantive questions, Mr. Chair.
Substantive, of course.
Thank you. You referenced the so-called sting operation that was undertaken by ABC. We heard from Mr. Duncan with a large stack of what appeared to be unregulated sales or transport or delivery into Kansas. Do you know, or does anybody here know, why in the world aren't we prosecuting these people? Isn't it against the law?
So, two things. One, that's one of the reasons that you passed the Fulfillment House legislation last year, is so that you could get that information and you could track down illegal shippers that are coming into the state. Mr. Duncan also cites in his testimony what some other states have done in their attempts to reach outside their state borders to prosecute for illegal shippers. Our director has been very conscientious about this issue. She does not have a separate unit in her department to pursue out-of-state illegal shippers, but they did because of COVID, because they weren't going out and visiting bars and restaurants and doing all of that stuff. They did a sting, and 95% of the spirits orders were delivered, even though that's illegal, into the state of Kansas. 100% of the beer that was ordered was sold and shipped, which is illegal in the state of Kansas. 71% of the wine was sold and shipped, which is authorized, but of that, several of them went to underage, and 50% of the vendors had no federal license and no state license. So we know that there's a problem. How far you want this department to go in reaching out? I know that right now they send cease and desist letters, and I couldn't tell you how much further they go in prosecuting illegal shippers into the state.
Mr. Chairman, I can't imagine that any of us would want to see liquor untaxed coming into Kansas, and so I hope we'll give that consideration as we look toward recommendations. My final question, very quickly, you had referenced in general terms violent crimes in the data that we obtained from, I believe this was this is from legislative research. I do note, though, that there wasn't any discussion here of domestic violence tagged crimes. There wasn't any mention of criminal damage to property by people who are intoxicated, and there wasn't any mention of disorderly conduct arrests for intoxicated people. It causes me to think that perhaps bad effects of people drinking are not confined to just sex crimes, robberies, ag assault, simple assault, kidnapping, sodomy, and sexual battery. Would that be consistent with your understanding that drunk people commit more crimes than just what we see in this table?
So the research is solid on that fact, and that's something that we have used in the past when we do our research based on not having unlimited numbers of liquor licensees in communities, because there is solid evidence that shows that the more liquor licensees exist within a neighborhood or a community, the higher the crime statistics are of liquor-related crimes. Having said that, we are very hopeful that these high numbers of consumption that we're seeing after the pandemic, that too will normalize, and that we're not going to see long-term negative effects. But if you read the studies that are out today and the ones that I cited in my testimony, they all say that the jury is still out on that information, and they recommend caution.
All right.
Thank you, Ms. Campbell.
Thank you.
Mr. Chair.
I'll take no other questions on this conferee. We're supposed to be adjourning or closing it down, and I've got 2 more conferees. So, thank you.
And you all know where to reach me.
Yes.
Thank you.
We all have your number. Next up is David Osgo with the Distilled Spirits Council of the United States. Is he here?
I am here online, Mr. Chairman.
Okay,
I hope you all can
please.
hear me. Excellent. Well, first off, I'd like to thank you all for the opportunity to be here with you today. I apologize I couldn't actually be there. We have another commitment here in Austin, Texas. But anyway, my name is David Osgood. We represent both large international importers of spirits, as well as over 200 small craft distillers here in the U.S. So you have my testimony, Mr. Chairman, so I will just take a few minutes to highlight some of my main points. One, about direct-to-consumer shipping of spirits, and secondly, about the taxation of spirits-based ready-to-drink products, or RTDs. First, let me say that we would not be advocating for any changes in the law or any changes in the regulation unless we're confident that such changes could be implemented safely so that you do not have an increase in underage drinking, and so that the state does, in fact, still continue to collect its taxes, and ultimately so that the state still has control. We really realize that with opportunity does come responsibility. So, as you mentioned, Mr. Chairman, the retail landscape in the United States is changing dramatically, and it's changing quickly. Probably for years, a lot of us have been buying a number of household items over Amazon, and then with the pandemic and everybody quarantining, shopping for groceries online really became the norm for a lot of people. It's a substantial change, year and a half. But it's not only groceries, they're also buying alcohol online. They're making their purchase of spirits, beer, and wine, typically through the 3-tier system via services such as Drizzly or Thirsty or any number of other third parties that have come up. In fact, during the pandemic, at one point, Drizzly noted that their sales or their business is up over 400%. So while the modern world allows consumers to make online purchases and get home delivery, we've seen a trend over the last, really 10 years or so, of consumers being able to buy directly from distillers, wineries, and breweries. There are over 2,000 craft distillers here in the United States. There has been an explosion of new distilleries over the last couple of years. And I don't know how many wineries and breweries. They all have tasting rooms. So the consumer has really grown accustomed to being able to go into those facilities and buy direct. So when you put together the fact that people have gotten used to buying from package stores online, and they also are accustomed to buying direct from distilleries, wineries, and breweries, it's no big surprise that today the consumer really would like to have direct-to-consumer shipping from distilleries. They would like to have the same kind of service that wine currently enjoys. So while the consumer wants direct-to-consumer shipping because of the convenience factor, well, it's A, convenience, B, the consumer also would like to have access to a wider variety of products that they can get, from distillers across the country. So the consumer wants convenience, but for the small craft distillers, it's really for them a matter of business development. As you all know, right now, if you're not selling through your distillery, you have to sell through a wholesaler. But unfortunately, there's been so much wholesaler consolidation over the last 20 years or so that in most states today, two wholesalers will control 90%, as much as 90% of the market. Well, as a result, if you're a small guy, that really doesn't leave you a lot of options. We hear continuously from the craft distillers that they just have a very hard time getting a wholesaler to take their product. And if the wholesaler does take their product, they really don't get much time and attention. And the problem's even worse if you would like to be able to expand outside of your home state. So if you want to sell outside your home state, boy, it's really difficult to get a wholesaler's attention. So for the craft distillers, now let me tell you, nobody in the distilling business wants to get into the shipping business. We see direct-to-consumer shipping is really augmenting the three-tier system. We see it as a tool for brand development within marketplaces that normally would not get that kind of attention. Ultimately, it's the goal of all distillers to grow smaller brands into larger brands that would be of interest to wholesalers. So we see direct consumer shipping as really augmenting the three-tier system, not competing with it. Now, let me turn for just 1 second to spirits-based ready-to-drink products, or RTDs. A spirits-based RTD is really just a single-serving cocktail or cooler with a spirits based in it. Typically, they're bottled at between about 5 and 9% alcohol by volume. So they're pretty much, most beers are somewhere between 5 and 10% alcohol by volume. So in Kansas, unfortunately, because of the tax structure, a 6-pack of spirits-based RTDs would pay $1.30 more, $1.30 more over a 6-pack of a malt-based product or a sugar-based product. So this puts spirits-based RTDs really at a significant competitive disadvantage vis-a-vis malt-based products. Ultimately, there's really no reason for this kind of discriminatory public policy. There's really no reason for this kind of treatment. There has been a blending. We talk about spirits, beer, and wine, but in a modern economy, there's really a blending of the products. And what we're really asking for is just a tax structure that recognizes the modern products that we have on the market today. And when you have, good public policy dictates that if two products have the same alcohol by volume, if they're the same ABV, they ought to be taxed similarly. So we urge the committee to allow direct-to-consumer shipping of spirits similar to the treatment that wine enjoys. Additionally, we urge the committee to alter the taxation of spirits-based RTDs so that they can more fairly compete in the Kansas market. And at that, I'd be more than happy to take a few questions.
Thank you, sir. Questions for the conferee? Yes, Representative Tarwater.
Thank you, Mr. Chairman, and I'm sorry for taking up so much time, just trying to get my arms around this. I have a question. Sir, you've heard in previous testimony that there's a tremendous amount of illegal shipping into the state of Kansas. There's a lot of taxes that aren't being collected, and there's issues with underage individuals having liquor shipped to their house. My question is this. My guess is that there's a lot of this going on because there's a demand for it, and there is no legal supply for it. And so I'd like to know from your experiences in other states that allow direct-to-consumer shipping. My guess is it would cut down on the illegal shipping because there's a supply line, and you don't have to get it illegally. I liken it to is not unlike gun sales, for example, in gun laws. When crime is high and we decide we're going to make more constrictive gun laws, crime goes up. But when you take less constrictive gun laws, crime goes down. And so this is, in my opinion, if we were to allow direct-to-consumer shipping, we would get rid of a lot of this illegal shipping, and we would collect more taxes, and we would do it right. Is that what you're seeing in other states?
You know, I have to completely agree with you. You know, ultimately, you know, businessmen don't want to be outlaws. They don't want to be criminals. And when you give them the opportunity, when you make it easy for them to ship a product legally, they're going to do it. Now, I must say, yes, there have been some well-documented instances. Virginia was an exceptional case study. They looked at their wine and they found that, gosh, we have a 34% non-compliance. Awfully high, very unfortunate. Now, as a percentage of their excise tax, it was pretty trivial, but you don't want to have that kind of non-compliance. So what did they do? You all mentioned earlier sending people not in compliance a cease and desist order. Well, they did two things. They sent them the cease and desist order, but they also sent them a form so that they could register properly with the state. And in a very short period of time, that 34% non-compliance went down to 3 or 4%. So it just goes to show, yes, and I admit ignorance of the law is no excuse, but when you make it easy people to comply, they will comply. They do want to pay the tax. So I certainly agree with you there, Senator.
Thank you. No further questions. Thank you, sir, for appearing here today by WebEx. Going to move to the next and last conferee, Tyler Rutt with the Wine Institute. Good afternoon, sir, and welcome to the committee.
Good afternoon. Thank you for having me, and I'll try to be as quick as possible. My name is Tyler Rudd. I'm with the Wine Institute. I'm the Central States Council. Wine Institute is a trade association of about 1,000 California wineries and associated businesses. Thank you for putting together this committee. I think it's a great idea to look at liquor laws and modernize them from time to time. And so I'll just jump right into what I'd like to see modernized in Kansas. Three things in particular. The first one being franchise law. The Wine Institute has been opposing franchise laws in every state that we are represented in. Particularly, the problem with franchise laws, for wine at least, and let me just stop and say I'm only speaking about wine because beer and spirits, they deal with their own stuff, so I'm just advocating on behalf of wine. But the reasonable cause that you brought up earlier has been the issue that we face in a lot of the states. There was one scenario that one of our members told us about, and it's about acquiring a different brand. So they're a winery, they want to acquire a brand from another winery, but the problem they have in these franchise states is they have to look at who the wholesaler is. And if their wholesaler isn't who they want for that brand, they sometimes can't even get out of that wholesale contract without litigation, et cetera. So even just making business decisions becomes problematic under franchise law. There was the Attorney General opinion that Chuck mentioned earlier. The question in that says specifically, you question whether the acquisition of one supplier by another or the change of ownership of a liquor brand at the supplier's level would constitute reasonable cause for the supplier who acquires the right to a brand to terminate and reassign the franchise agreement that existed at the time of the acquisition. Basically, we had a change of ownership or want to acquire a brand. Is that reasonable cause? Now, I would say in a business sense, it's definitely reasonable. But the Attorney General disagreed with that and said that this is a case where it's actually not reasonable. So that in and of itself shows you the problem that wineries have with franchise laws, because getting out of their franchise agreement is very problematic. In 1979, when this was passed, I would imagine that it was different. It could be there were a whole lot of wholesalers, not a lot of suppliers. That has flipped over the last couple of decades. 80% of wine that is sold in America is distributed by 10 wholesalers. The bargaining power that may have been a problem back in the days is not existent anymore. The Attorney General, in his opinion, actually said that there has to be an evening up of the bargaining power. That was the reason. Well, that bargaining power is quite opposite now. It's much more difficult for wineries to actually get a wholesaler than it was back then, as opposed to vice versa. There are 11,000 wineries in the state, in the country, and about 250,000 SKUs or wine brands that are being distributed. So 80% of those 200,000 of those SKUs are distributed by 10 wholesalers. And in Kansas, I think, as far as I know, and Tuck can comment on this, but I think there are 5, at least in his membership, so 5 wholesalers to distribute, give or take, 250,000 different brands of wine. So we would like to see basically that wine be removed from the franchise law. That's our biggest request. If that doesn't suit you, we would also be happy to discuss getting rid of reasonable cause, because that really is the problem that we face in our industry. We just basically don't think that the government should tell 2 parties what they can put in their contract. We don't like government involvement most of our lives. Why would we want it necessarily in agreements? Excuse me. The second thing I want to talk about real quick is the RTDs. It's been brought up by various people. And in Nebraska, last session, I think Tuck actually mentioned the bill, but it was actually rolled into Legislative Bill 274, and it created a definition for ready-to-drink beverages, which was a spirit-based beverage less than 12% alcohol by volume. Initially, the bill said that it was going to be taxed at the same rate as malt-based beverages, which, of course, Wine Institute, we were unhappy with that, and so we requested that the legislature change it and at least make it equivalent to the wine rate, which in Nebraska is 95 cents per gallon. They actually listened to us as well as the head of the ABC in Nebraska and made the ready-to-drink spirit-based beverages taxed at the same rate as wine. So we were not opposed to that. And that's what we would encourage you guys to look at, guys and women, I should say. If you do look at RTDs, that you consider not putting it such that wine is at a disadvantage. The last couple of things. One, the tax rate for wine is based on a percentage of alcohol by volume at 14%. If it's lower than 14%, it's one rate higher. It's a higher rate. Just a heads up, if you don't already know, there was a federal law passed a couple of years ago, the Craft Beverage Modernization and Tax Reform Bill. It raised that rate to 16%, and we would love to see Kansas and other states that have roughly the same consider that as well. And finally, I'm happy to answer any questions about direct shipment of wine. We are eager to find out what happens, what we can discover from the fulfillment law that everybody was helpful, including Chuck helping us, bringing us in the fold since we're the wineries that do the direct shipping, to figure out who are the bad apples. That's what we want to know, because they make us look bad. So if you have any questions, I'm happy to answer.
Thank you. Questions for the conferee? Just one. On the reasonable cause part of the agreements that's in Kansas law, I know there's 22 other states, I believe there's 22 other states that has these franchise agreements in statute. Do they all have the same standard of reasonable cause, or is there a definition in their statute what reasonable cause is?
Some of them do have a definition. They treat it differently depending on the state. For example, Georgia, if you want to get out of your contract, the state law allows you to take your brand off the market for 4 years. And then you can bring that brand back in the market with a new wholesaler, which some of our members have done because it was worth it to them to just take the product off the market to get a new wholesaler. Other states, Delaware, if you get out of a contract, there's an exception for good cause if basically you pay the wholesaler a certain amount of money. I think it's 1 or 2 times their inventory or their profits from the previous 3 years, something along those lines. So a pretty hefty check. Our members are often willing to write that check just to get out of that franchise agreement. So it really depends on the law, but almost everyone, and again, I think Tuck, having practiced law for many, many years on this, he would probably be able to tell you exactly how many, but I'd say almost all of them, if not all of them, have some sort of reasonable cause, good cause. But these days, those states are a minority.
Okay. Thank you. Further questions based on my inquiry? Yes, please.
Thank you, Mr. Chair. Speaking of that, I mean, I think Tuck kind of answered that question a little bit. So litigation in Kansas on franchises. How many times has that happened that you're aware of?
Well, to be honest, I'm not aware of any. I'm sure it's happened in the past, maybe not at the district level, maybe they settle, but I don't know of any. I don't practice law in Kansas.
Okay. And then second part of that is another kind of a testimony we heard a little earlier. When a distributor takes on a brand from a manufacturer, let's just call it brand X, and brand X actually gets sold to another winery or whatever that is, there is some kind of to be said there when distributor has actually put a lot of effort into this brand and built this brand and has really worked this brand hard in the state, just to have it pulled out from under him for really not reasonable cause, I should say.
I don't disagree with you at all. I think the difference is now the wholesalers have so many brands that some may not, they don't work as hard with some brands perhaps, so that if you're the supplier who has a brand with one wholesaler and you try to get out of that and take your brand away from them, that wholesaler still has like hundreds, I don't even know, hundreds and hundreds of brands of other things. So while I'm sure the wholesaler doesn't want to lose that brand, it's not going to crush their business because they have so many these days. With all the consolidation of wholesalers that I don't want to say cornered the market, but as I mentioned, 80% at least of the wine that's sold in America is by the top 10. And generally, I would say they're more like 5 that control it all. So they don't lose a whole lot if a supplier takes it from one to another.
Where I have some, excuse me, some problem with that is if I'm a supplier and I have a brand, say Jack Daniels, and that gets pulled off and goes to a different wholesaler, you're telling me it's like, well, hey, I have 20 other local whiskey distilleries, that should cover it. I should be okay.
Well, I would say you have more like 200, instead of 20. But at the same, if you want to flip the coin, if you're a supplier and you have this product, this bourbon or whatever it may be, and the wholesaler's not putting out there in the way that you want that wholesaler to do and not marketing it and doing all the things that you want that wholesaler to do, it's really tough to get out of that, to say, I don't want to use you anymore. I want to use this wholesaler over here. And this wholesaler's like, well, sorry, you don't have a reasonable cause. And so it leaves us stuck to stick with somebody who's not doing as good of a job as this person or this wholesaler would do.
So I think we've identified pretty much 0 litigation so far that we can cite.
Happy
but
to defer.
But so have any of your clients ever gone through that process? Have they ever asked a distributor, we don't want you to be our distributor anymore, we want to go for somebody else? And has that, what I'm asking is, how many situations on the people you represent has that happened where the distributor did not allow that to go through? Because I talked to a lot of my distributors, there's not a lot, but several of them, and more than likely, if they're having that conversation, they find a way to let it go. They find a way to let you out of that agreement. Are you saying that that's not accurate?
Again, I don't know specific scenarios that I can mention right now.
In general?
What I can say is when this committee was put together, I asked all of my members, or at least the ones that are part of our state relations committee, and I said, what are the issues you're seeing in Kansas that you would like to see changed? And every single one said franchise law. So I guess there's a problem there if they want to change it, but they didn't give me specific scenarios other than the one I mentioned about trying to acquire brands and the problems that come with that.
Thank you, Mr. Chair.
Thank you. Further questions? Seeing none, thank you, Tyler, for being here today. Committee, tomorrow, I hope to get us out of here by 12:30. I would say at 12 o'clock is the memorial for law enforcement memorial, which is out in the rotunda, and then there will be.
12 o'clock north of the Capitol.
Thank you. The North Capitol at the memorial out there. So I would encourage, if you wish to make it, we'll get out of here in time so that you can make it. But we have some conferees tomorrow. I'm just looking at some dates for our last meeting, and we're not going to make that today, but I'm looking at November the 10th. If you look at your calendars, get back with me tomorrow before we adjourn. Anything else for the good of the committee? Seeing none, we are adjourned until 10 a.m. tomorrow morning.